I just want to note for the record that Justice Gaziano is not participating in this case. He's recused. Justice Lowy is participating in this case, but he is having problems with this video feed. And the chief is also watching and will be participating in the ensemble of this case. So if I can ask Clerk Keneally to call the next case.
SJC-12882, William Dinkins and another, v. Massachusetts Parole Board.
Great, thank you. Mr. Schiff.
Thank you, Justice Budd, and may it please the court. My name is Ryan Schiff, and I, along with Lisa Newman-Polk, represent the plaintiffs, William Dinkins and Eugene Ivey. At first glance, the parole board regulation in this case looks like nothing more than a boring, mundane rule governing parole eligibility conditions. But what it actually does is far more radical. It creates a new kind of parole for a whole category of prisoners that is incompatible with what the law has traditionally understood parole to be, and more importantly, is in direct conflict with multiple Massachusetts statutes governing parole. This regulation creates a new legal entity, the incarcerated parolee, kind of like Schrodinger's cat. This person is simultaneously at liberty on parole and at the same time deprived of their liberty, locked in a prison cell inside the prison walls and enclosure. This regulation is in the teeth of two clear statutory mandates. First, Chapter 127, Section 133, contains an explicit aggregation mandate requiring, quote, that where an inmate is serving 2 or more consecutive or current state prison sentences, a single parole eligibility shall be established for all such sentences. This aggregation mandate is clear and by its own terms applies to all consecutive sentences. The second statutory problem for this regulation is well illustrated by Eugene Ivey's situation right now as we speak. Section 130 of Chapter 127 says that, quote, a prisoner to whom a parole permit is granted shall be allowed to go upon parole outside prison walls and enclosure. On March 26th of this year, the parole board issued a parole decision granting Mr. Ivey parole from his life sentence. A few days after that, he was called into the institutional parole officer's office at his prison, and he was handed a permit issued by the parole board. Yet despite literally having that parole permit in his hand, when he walked out of that office that day, he was not permitted to go upon parole outside the prison walls and enclosure, but rather was sent back to his prison cell, locked inside the prison walls and enclosure. Outside the prison walls and enclosure does not mean inside the prison walls and enclosure. This reality simply cannot be squared with the clear mandate of Section 130. All we ask.
Mr. Schiff,
Yes.
I appreciate and I really like the way you're walking through the different statutes, but I'd like you to go to the third statutory provision.
Yes, Your Honor.
Which is why this case is hard. This is 133A. Every prisoner is serving a sentence for life, and those prisoners shall be eligible for parole at the expiration of the minimum term fixed by the court under Section 24 of Chapter 279. So don't we have a conflict between these three different statutory provisions that we got to work out?
No, Your Honor, I don't think there's any conflict whatsoever, and I'm glad that we're going to the language of the statute itself. That's what I was going to propose we do, because I think it's important that we look at the details of the language that the legislature actually used. So this Section 133A is reproduced in the blue brief at Addendum 68 and the red brief at Addendum 63. And the first sentence of that section really does a very important thing. And the primary thing it does is actually the thing that it does in the middle, which is that it says people are eligible for parole who have life sentences in Massachusetts, all of them, except for 3 categories. And then the other part, which is really grammatically the main part of the sentence, is a rather straightforward thing, which is that they are eligible for parole at the time set by the court under Section 24 of Chapter 279. And then if we turn to Chapter 279, section 24, that is a statute that governs not just the imposition of or the establishment of parole eligibility for people serving life sentences, but for all prison sentences. And they do not specify here anything about one part of that statute over the other. Then if we move to the second sentence, and this is really at the meat of this case and the parole board's whole case is the second sentence. It says that the parole board shall, and now we're turning, if you just read the statute, not from what sentence has been imposed by the court, but now what happens when it turns over to the parole board. I'm sorry, Your Honor.
I want to make sure I understand. So when it says prisoners shall be eligible for parole at the expiration of the minimum term fixed by the court under section 24 of 279, you say that's not not the minimum term fixed by the court for the life sentence, but rather the aggregate sentence? Is that what you're?
Well, I was going to get to that in just a second. I think it becomes important once we get to the second sentence, and it shows why there's no conflict here whatsoever.
Go ahead, you get there as you.
So once we get to second, I'm sorry, Your Honor.
Go ahead, get there as you see fit.
Okay, thank you, Your Honor. So the second sentence then says that the parole board shall, within 60 days before the expiration of such minimum term. And now we're pointing exactly back to what Justice Kafka was talking about, to the minimum term that was fixed by the court under section 24 of chapter 279. So we agree that that 60-day requirement is important, but it's a requirement on timing of when parole hearings take place. It doesn't speak to aggregation. And the way to read that such minimum term consistently with the aggregation mandate in section 133 and the outside the wall prison walls and enclosure mandate of section 130 is to read that to say the minimum term after normal aggregation principles are applied. But then it goes on to say that the parole board shall conduct a public hearing. Now that public hearing is important because with one other exception, public hearings generally are not held by the parole board. Usually they're non-public. So here, using very clear, explicit, unequivocal language, the legislature has shown that for people serving life sentences, it knows how to create clear, unequivocal exceptions. And then it goes on to create another exception, which is for people serving life sentences, only they are entitled to hearings before the full board. Everybody else gets hearings before part of the board. So here we have in that one sentence, the legislature showing that it knows how to create clear exceptions and creating two clear exceptions to the normal rules that apply. What it doesn't do is in any explicit or even implicit way say anything about aggregation. That 60-day rule, and we discussed this in our reply brief, the purpose of that, particularly when you go then to the next sentence, which says that they can delay until 30 days based on the proper findings. The purpose of that is to have a parole hearing early enough that if you're granted parole, you can meet the standard for parole. There's at least a possibility that you'll get out of prison and go outside the prison walls and enclosure upon parole on or about your parole eligibility date. But what that doesn't do is say anything about aggregation. And we know, from the statute itself that the parole board knows how to create clear exceptions for life sentences. But we also know more generally that when the legislature does want to create exceptions, it doesn't do so in cryptic language. It doesn't speak in code. It doesn't, as the Supreme Court has said, hide elephants in mouse holes. Mm-hmm. So if there is any question though left about whether what this is actually doing is creating an exception to the aggregation rule through this kind of cryptic coded language, it's put to rest by the very next section. And this is reproduced in our reply brief at addendum 21, and that's section 133B. So just like how 133A sets out special rules that apply for life sentence cases, this is setting out special rules that apply for people who've been sentenced as habitual criminals. And it, in its very first sentence, uses almost identical language. It says the parole board shall, within 60 days before the expiration of 2/3 of the maximum sentence of a prisoner sentenced under section 25 of chapter 279, which is the habitual criminal statute, and thereafter at least once in each ensuing 2-year period, carefully and thoroughly, consider carefully and thoroughly the merits of releasing such person on parole. So we have almost identical language. And in fact, if anything, this language more supports an exception to the aggregation rule, because it's not saying, as 133A says, at the minimum sentence established by fixed by the court, but rather a specific time, which is 2/3 of that single sentence, the one imposed as a habitual criminal. Yet the parole board does not interpret this language to create an exception to the aggregation rule, and it's offered no explanation for why it would have that radically inconsistent interpretation of almost identical language. Now, it gets even more difficult, I think, for the parole board if we turn to section 136 of chapter 127, because this is, once again, we have, the parole board acts as though 133A is kind of unique in that it establishes separate rules for life sentence hearings, and therefore don't pay any attention to the aggregation rule because it's in a separate statute or a separate section. But that's it. I'm sorry.
Break your flow here for a second.
Yes,
So,
Your Honor.
is there some value? So for the person with the life sentence, you're saying we don't want you to have this parole hearing until we aggregate these two sentences, right? It's
Yes.
going to be pointless. We're going to have two hearings. But is there some, at least, I mean, it may be esoteric, but value that the life sentence is being put behind and it's being done earlier, in the sense that this is the big 600-pound gorilla, the life sentence. And is there a value of having that parole hearing earlier so that, the prisoner understands, okay, now we're on a fixed time schedule at this point. We're not having this life sentence hanging over indeterminate for another couple of years, or, is there some value of pushing that forward? And is that what the legislature was intending when it required? I know you have this reading of 133A that it's somehow an aggregation, but I'm not sure I get there. I'll wait and hear the Commonwealth on that. But
Okay. So I'll answer that in two parts. The first part is we certainly are not reading anything out of section 133A. As I said, we think that the 60-day rule does something very important. Now the other question of whether there's some kind of benefit, no, I don't think there's any benefit whatsoever for anybody who is serving one of these sentences. I'm not going to speak to the psychological benefit that any of the dozens, if not hundreds of people impacted by this regulation feel, but there are real world negative impacts for the people impacted. The first one is the one that was pointed out in the single justice's decision in relation to Mr. Dinkins' resentencing, which is that people are sent back to prison with no defined parole eligibility date. So you can go into a prison and you can ask a group of prisoners, when are you going eligible for parole? And you go around the table and all of them can tell you the date when they're eligible for parole, until you get to the person impacted by this statute, and they cannot tell you when they will be able to sit before the parole board and make their case for release into the community, which is the only thing that really matters to a prisoner. But there is also another more tangible downside to this, and this is a point that was made in the Prisoner Legal Services amicus brief, which is, I'm going to take William Dinkins as an example because he has 2 life sentences with parole eligibility at 15 years. Now, Mr. Dinkins is now either 47 or 48 years old, and he has not been paroled from his first life sentence. If the parole board, when he's 50 years old, decided that they was going to then parole him from his first life sentence, and that would be a decision that would be based on its ordinary parole decision of whether he can, there's a reasonable probability that he can live and remain at liberty without violating the law, and that his release is compatible with the welfare of society. So they made a determination that he can live at liberty without violating the law. They would then send him back to prison, and it would be another 15 years before he could go before the parole board when he's 65 years old and actually ask for release into the community. And there is no ability of the parole board to look that far into the future, make that kind of prediction that it's going to take another 15 years for him to be ready to be released when it's already made the determination that he's ready to be released. I'm sorry, Justice Cipher.
Thank you. Two questions. The first is there, I see that there's pending legislation amending this. Do you know if that affects this problem in any way? It's kind of hard to tell from the way they've written it, but they strike the first paragraph and then say it aggregate, it's 133 section 127. Are you familiar with the pending legislation?
I am not, Your Honor.
Okay, there's several different kinds pending for different issues, but this one pertains to people serving life sentences for murder who have attained the age of 18, unless they preserve the exception for more than one life sentence. And that, so then putting that aside, my other question is really, so if we just took that regulation away, how would you implement these statutes in these cases? What are you saying should be done?
Yeah, okay. Thank you, Your Honor. So what I think should be done is the same thing that's done in just about every other type of case and done successfully. And that is just to aggregate the sentences. So let's take, for example, William Dinkins' situation once again. So he has 2 life sentences with parole eligibility at 15 years. You know, as it stands now, he has no real set parole eligibility date. He doesn't know when he can walk before the parole board and ask for his release into the community. If they're aggregated, then you just add together the first 15 and the second, and you have a single parole eligibility at 30 years. And the fact that they're consecutive sentences serves its purpose. There is a big difference between a person being sentenced to life in prison and having parole eligibility 15 years later and having a chance to be released 15 years later, compared to somebody who's much harsher sentence, a sentence that fully, if we aggregate, still takes into account the intent of the sentencing judge of having to wait 3 decades rather than a decade and a half to go before the parole board. And what that does, it serves everybody's purposes, because as we have it now, we're having these lifer parole hearings are extremely resource intensive. And the parole board, at a time when it's taking close to a year to release lifer parole decisions, is having to conduct unnecessary life sentence hearings where there's no chance that the person's going to get out, in some cases for decades to come. And then if they deny parole, then they have to do it all again somewhere between 1 and 5 years later. So it doesn't help the parole board because it wastes its resources. It doesn't help the DA's offices because they have to spend the resources deciding whether to weigh in on these cases, and if they decide to, writing letters, sending an assistant district attorney to spend a good chunk of the day waiting to testify, and then testifying usually against parole. It also doesn't serve the interests of victims' families who are forced to go and make a decision about whether to appear for parole hearings decades before they might otherwise have to, at hearings that don't have any chance of releasing the person from prison. They, instead of waiting until 30 years after the conviction and sentencing, they could go in at 15 years rather than 30 years. And it's certainly, for all of the reasons that are set out in the law school clinic's brief, amicus brief, doesn't benefit prisoners at all. It dramatically interferes with their interests. So this is, I don't think where we have clear, unequivocal statutory language, there is any weighing of costs and benefits, but this is a regulation with all costs and no benefits. So it isn't as though this is filling in some gap that was left there by the legislature. Aggregating, as this court made clear in 1975 in Henschel, makes little sense. And the reason why the court said it made little sense is because of the actual standard for parole. The standard for parole is there a reasonable probability that you can live and remain at liberty without violating the law, and whether your release is not incompatible with the welfare of society. So what that standard is asking is this person, as this court made clear in Henschel when the same standard applied, is whether the person is ready for release. But that standard makes no sense when the result of the hearing is that the person isn't released, but rather goes back to prison. And that's why this court explicitly and quite literally said this process makes little sense.
Does anyone have any other questions?
No.
Okay, Attorney Zalnowski.
Thank you.
Thank you. Good morning. Jennifer Zelnowski, representing the Massachusetts Parole Board. The plaintiffs claim that the board's long-standing policy and regulation is in conflict with chapters 127, section 130, and 133. But the plaintiffs do seem to overlook that it is actually chapter 127, section 133A that governs all aspects of parole eligibility for those serving life sentences. The regulation clarifies that statute and has done so, and the board has done so consistently since it implemented this as a policy in 1988 and then as a regulation in the early 1990s. We often talk about parole eligibility, but what really the board does is calculates a parole ineligibility period when it comes to those serving sentences with a minimum and maximum term. And this determines the time period a prisoner must serve before he is eligible for parole. But with life sentences under section 133A, this minimum term is actually fixed by the court. And that leads to the differences in between the two statutes. And what this case ultimately comes down to are common principles of statutory and regulatory interpretation.
Before you leave that, I just want to, and I'll be honest, I didn't fully understand defense counsel's attempt. But when you look at section 24-279, it has two parts. It's not just a life sentence part, it also has an ordinary sentence part. So I think his argument was, no, 133A still requires you, because of the first paragraph, maybe you can do this aggregation under that. The first part of 24-279 is talking about ordinary sentences too. So can you address that?
Yes, Your Honor. I think that if you actually look at the language, and that particular statute has also recently amended, I believe it was 2014, specifically to address minimum sentences for juvenile homicide offenders following the Diachenko cases. So it specifically sets out minimum sentences for those that have been sentenced to life on first-degree murder. But in addition,
but it also has another part of it, which is talking about ordinary sentences. So
it does.
And we have to reconcile 133A with this sort of more straightforward language in 133, where an inmate is serving 2 or more consecutive or concurrent state prison sentence, a single parole eligibility shall be established for all such sentences. So I'm just trying, we're stuck with a bunch of statutory language that's not completely reconcilable, right?
Well, I would disagree that it's not reconcilable, Your Honor. I think if you look at 133, that would be a.
Go ahead.
I'm sorry. Section 133 is certainly a more general statute that addresses prison sentences. But as we pointed out in our brief and continue to assert here, the legislature then enacted a totally separate statute, 133A, that addresses every prisoner that's serving a life sentence. And this court recognized that in Crowell, that there is a difference and that statute does set apart life sentences. So I think that's important, and there's a time difference there. So the life sentence one comes later. I also think that if you look at section 133A and compared to 133, there is significant language that's missing in 133A that which discusses the single parole eligibility date, the consecutive sentences, and aggregate. Those words don't appear in section 133A. The board's position is that was intentional by the legislature, that this is not how they wanted life sentences to be treated. When they amended 133 in 1993, they didn't include those words in 133A, despite the fact that they've already created this statute to address every prisoner who's serving a life sentence. So our position is that 133A sets out specific mandates for those prisoners separate from those that are serving a prison sentence for a minimum or maximum term. So they are reconcilable because we're treating these as different categories.
All in 130 though? Is that, because it does use the word all. I mean,
It does use the word all, Your Honor, but it also doesn't say anything about life sentences. And it only talks about state prison sentences in terms of minimums and maximums. So I think that's where 133A comes in to clarify that exception, that the legislature is saying there's this section of prisoners, and then there's this other section that are serving life sentences, and we're going to address them in this statute.
Okay, so say I'm still confused by these two statutes, and I'm just not sure, and I'm trying to create some kind of coherent, logical system. Why would we have two parole? What's the value of having this sort of premature parole hearing where we know the person's not going to be released by the state system at all? He's just going to have a do-over of the exact same thing 2 years later or 4 years later, or in the case of this defendant, 15 years later.
I'm not sure that it comes down to a value base. I think when you're looking at the language of the statutes and the regulations, this is how the legislature intended it to be. They intended to treat life sentences differently, just like they have a bunch of different criteria that they have to meet in order to be paroled, and that they have the 5-year setback, and there are different criteria for those serving life sentences. And I think that is how the legislature has wanted it to be. They want them to serve their life sentence and then to serve a consecutive sentence. And it's not unusual for somebody to serve a consecutive sentence.
But part of what they're doing for the life sentence is deciding, I understand they're serving the minimum term, certainly, but they're also deciding whether they're ready to be released. You know, they've done amount of time, they've shown they've understood, they're ready to be in public, but then we're gonna, instead of waiting for that moment for when they're actually going to be released into the public, we're gonna do it twice. The second proceeding is going to be completely odd, isn't it? So we've decided this person's ready for parole, and then 15 years later, in this case, we're going to do it exactly over again?
Well, I think
Yeah.
Oh, I'm sorry, I didn't mean to cut you off.
No, go ahead.
I think that part of that has to do with the standard has to be the same. You can't have a different standard just because they're going to serve another sentence. So the standard has to be the same, that this is what, if they meet these requirements, this is how they get paroled from this sentence. And that makes sense. Whether they're going to serve their second sentence, that's how the judge ordered that sentencing to take place.
May I interrupt and ask you a question about this? Suppose somebody doing their first life sentence receives a favorable parole determination at 15 years, and now their second life sentence is starting. Is there anything that could happen to them in the second sentence while they're serving the second sentence that could retroactively affect that parole the first time, so that it is revoked or something? Could they get in trouble and
certainly,
lose
Your
that
Honor.
first parole?
Certainly, Your Honor. I think that 133A actually addresses some potential for that.
Mm-hmm.
For example, if you're paroled into your second sentence and the parole board issues certain conditions for you to follow while you're paroled from your first life sentence, if you will, and now you're serving your second life sentence, you are to remain D-report free, you are to attend certain types of programming, those types of things, not commit any other crimes. If you violate those, the parole board can violate your parole, and they go through all the regular procedures that they would on any parole violation and revoke that and set you back into your first life sentence. And that is a possibility.
Do you know how many of these there have been parole hearings in these circumstances?
Of life sentences moving
Yes.
into a second sentence?
Yes.
I believe part of the record does include several copies of the decisions. I don't have an exact number, Your Honor. I could certainly get that from the parole board.
It's all right. Thank you.
Certainly.
Justice Lowy?
Thank you, Justice Budd. I understand your argument about 133A, and I follow the way that you get there. But isn't it a much simpler and straightforward analysis to say, well, 133A doesn't mention aggregation, it doesn't mention consecutive sentences. 133 references 279 section 24 that refers to life and not life sentences. And 133 defines when an inmate's eligible for parole for all state prison sentences, because murder is a state prison sentence. So isn't that the more straightforward way? I understand the way you did it, but isn't it just much simpler the way that I just stated it?
I would disagree with you, Your Honor. I think it's just as simple to look at the two different statutes that address two separate categories of sentencing. I think
But 133A doesn't have aggregation or consecutive sentences in it.
Right. And it's the board's position that that's an intentional, that was intentional by the legislature, because they don't want life sentences to be aggregated with consecutive sentences. So that is an intentional omission from that section of the statute when addressing parole eligibility for those serving life sentences. And I think the fact that the opening line for section 133A says every prisoner who is serving life sentences. So while I understand 133 has the word all in it, you also have to address that 133A says every prisoner who is serving a life sentence. And then the court goes on to say, or the legislature goes on to say, shall be eligible for parole at the expiration of the minimum term fixed by the court under Chapter 279, Section 24. Now, the plaintiffs like to push this, that we're relying heavily on the 60-day part, that's the mandate of 133A that we're relying heavily on. But actually, if you look at the history and go back to the 1988 policy and the 1990 memorandum and the 1994 memorandum from the board, what they were really focused in on when they were originally enacting this was that part of the statute. Now, that part of the statute has changed. Initially, at one point in time, it specifically said the minimum term was 15 years for a life sentence, and then it had since been amended to the minimum term fixed by the court, and then makes the reference to 279, Section 24. But in that section, it does lay out what minimum sentences are appropriate for life sentences. So I think that all makes sense. That's really the purpose of the board's regulation dating back from its initial inception in 1988. It's that date that they're focused in on, that when a prisoner is serving a life sentence, that's the day that becomes his parole eligibility date on that life sentence. And if a judge chooses to order a sentence to be served consecutively from that life sentence, it doesn't get aggregated. And that is the board's interpretation. And it's a reasonable and logical interpretation when you look at all of the statutes together. And under the principles of regulatory interpretation, we would ask that this court deem that the regulation is valid.
Go ahead, Justice Kafker.
In terms of the deference issue, so we have a change in policy, right? They used to aggregate and then they didn't. And what triggered the change? What, from the record, can we determine why they stopped aggregating life and other sentences?
Your Honor, I don't believe there's anything concrete in the record. My recollection from when this case was in the Superior Court was there was some discovery that was done to try and attempt to find more history for these cases. But as it turns out, it appears that before 1977, the board did not aggregate these sentences. And then after Henschel, it did aggregate these sentences, and the board reviewed that policy again, and in 1988 came out with its policy that it was going to follow what the statute said, and that would be that.
That statute, when did that statute pass? When did 133A pass?
The first version of it, I believe, was 1955, Your Honor.
So it's
I have it in my brief. I might be blanking on the day.
So there's not a statutory change that generated the change in policy. They just changed their policy. It could have been they didn't want to hold those hearings until longer.
I believe there was some statutory change, but I don't think it affected that part of the statute, other than I think the dates changed. At one point in time, I believe at one point in time in the 60s, the minimum sentence for a life sentence was 20. Then it changed to 15, and now it's changed again. So I think that's why the legislature has gone with the minimum term fixed by the court.
Well, why would we show any deference if the parole board is like ping-ponging around on this issue?
Well, I would certainly disagree with the characterization that they've ping-ponged around, Your Honor. This
How
policy,
about it's changed 3 times without any sort of clear reason why it's the first change makes sense. Henschel triggers it to aggregation. The second change back, we can't discern any reason for it.
right, but as an administrative agency and as a government agency, Your Honor, the board certainly does have the authority to address corrections in their regulations and their interpretations, and they've changed it. They've only,
Don't they have to provide some explanation if they want us to defer to it? I mean, I'd be happy if they said, oh, because of the language in this amendment, we made this change. Then we say, great, deference. But if they just change it out of nowhere, do we owe any deference to that?
yes, Your Honor, I believe that the case law would still suggest some level of deference to the board's decision, especially since it's been such a long-standing policy. It's been in place since 1988 and then has been implemented into the regulations since then. I do think that the board as an agency does have that authority and the discretion to look at the statute and determine that when we look at Henschel, it doesn't actually talk about specifically 133A. And if the board then reviews that and says, this isn't what this says, and as they explained in their regulation policies, in their policy manual in 1988, that's why the policy became what it was because of that minimum term. And if they aggregated it, the life sentence, those prisoners serving a life sentence wouldn't get their hearing at that particular date. And that's been their policy since then. And I think it does deserve a certain amount of deference, especially in light of the fact that not only has the policy not changed, but when the statute was, section 133 was changed in 1993, 133A didn't change at all. And I think at that point in time, if you're going to make that kind of legislative change, that the legislature didn't make that change and the board continued with that policy, certainly deserves some deference based on a legislative acquiescence. And that's addressed in our brief as well, Your Honor.
A question has come over the transom from the chief, so I'm
Okay.
going to ask that on his behalf.
Sure.
Is there an inherent contradiction in having a parole hearing which cannot yield a parole release, where parole is defined as a release from custody?
I don't think that it is an inherent contradiction. I think, and we reference this in our brief as well, I think the Superior Court provides some helpful analysis that not every prisoner is paroled to the community, that certain parts of the statute can apply to a specific sentence. And I think the Superior Court addressed it maybe a little more eloquently than I'm doing right now, but what they're getting at, and I agree with their position, is you can be paroled from one sentence to serve another sentence. We've had consecutive sentences before. I don't think it's a contradiction that happens. It's not, it may not happen in every instance, but I also don't think the fact that language appears in 130, it certainly isn't enough to under regulatory interpretation standards to deem the whole regulation invalid. It may not be a perfect fit, but I don't think it's a contradiction that somebody can be paroled from one sentence into serving a consecutive sentence.
Does anyone have any other questions? Okay, great. Thank you, counsel.
Thank you.